Hello. In this clip from our Justia webinar, How to Effectively Handle Long COVID Disability, Edward Dabdoob shares some tips about how to communicate and file long COVID disability claims with insurance companies while answering doubts from the audience. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Briefly, I want to just get into 2 or 3 cases, and then we'll stop to take some questions. There's a wonderful case that was handed down by the 11th Circuit in 2022, Sisson versus Unum. And one of the things that you see insurance carriers will try to do to your neuropsychological evaluation is they would take the whole report and toss it out, because there are a lot of validity testing that's built into the report that I had discussed earlier. Let's say there are 3 separate validity testing and your client failed one. What insurance companies are going to do is discredit the entire report, throw the whole thing out, throw the baby out with the bathwater. But that's not okay. So what the Sisson court spoke to here is you can't throw the baby out with the bathwater because you didn't like one of the validity testing out of the 3 tests that were done. The court said, well, the other testing were reliable. So maybe one part of the neuropsych eval wasn't necessarily reliable, but the other parts are. And so the court faulted Unum for taking the whole thing and throwing it out. And so this is a good case for you to cite to argue that it's unreasonable to disregard the entire results of a neuropsych report because maybe 1 or 2 parts of it isn't perfect. And that's the whole idea, right? We are not required to present perfect evidence. We are required to provide sufficient proof of disability. So when you take your neuropsych, even if it's not perfect, and then you get it independently validated by another neuropsychologist, then you pair that up with the Sisson type argument, a court's going to rule in our favor on these issues. Abrams versus Unum, another Unum case. Interesting. Abrams was a trial attorney. He was making somewhere over $500,000 a year, working 12 hours a day. Then he got ill. Fevers, brain fog, weakness, fatigue, cognitive impairments. Those are some of the symptoms he was experiencing. Interestingly, and this is not unusual, Abrams saw 7 doctors. 3 said, yes, he has long COVID. 4 said, we think it's chronic fatigue syndrome. Importantly, though, even though the 7 doctors couldn't all agree whether it was COVID, long COVID or chronic fatigue, they all agreed he was disabled. And that's what counts. Now, what happened in the case is after his appeal was denied, Unum argued he didn't meet the diagnostic criteria for CFS. And so what they're doing is they're attacking the diagnosis. And a lot of plaintiffs' attorneys make the mistake of going down that rabbit hole because it's a shiny object. Let me chase after it. Let me prove to you the diagnosis. Don't do that. Because the case law does not require, the insurance policy does not require, none of those 2 things require that you prove the etiology. You must prove symptoms that are causing restrictions and limitations rising to a level that your client can work on a consistent and reliable basis. The court didn't go down that rabbit hole. The court didn't fall for it. The court instead ruled in favor of Abrams, recognizing that he has brought forward sufficient proof of disability, even if they couldn't figure out exactly what was the cause. Last case, Vastag versus Prudential. I loved this case when it was handed down. Why? Because this is the first case where a federal court accepted CPET testing and said, not just, is it good? The court referred to it as the gold standard. And not just that it's the gold standard, but the court then said, this is objective medical evidence. So you can cite Vastag as the gold standard testing for CFS cases, long COVID cases, and then you can point out this is objective medical evidence. So now you're taking your long COVID case out of the realm of a subjective disability and you're thrusting it onto the insurance carrier with loads of medical evidence that is now objective medical evidence. The reality is that the insurance carriers cannot argue that you haven't met the burden of proving disability. One of the things we do after we submit our disability appeal is we start to then polarize the evidence, polarize our doctors against the insurance company's doctors, right? And we do these by sending very short, precise letters with a few questions to the insurance companies, questions that have no good answers for the insurance companies. And one of the questions we also like to ask is, let us know what, if any additional medical documentation or other information that you insurance company would like to see to finally approve benefits. And against the backdrop of having submitted overwhelming proof of disability and nothing else out there medically to give, they will never have a good answer for it. And I'll conclude by saying the majority of these appeals get approved. And if you end up in litigation, you are going to be in great shape no matter what the standard of review is to challenge an insurance company. With that, I will conclude and ready for questions.
Awesome. Thank you, Edward. Okay, we can now move on to the audience questions. So just a reminder, if you have a question for Edward, please feel free to place it in the Q&A button in the control panel at the bottom of your screen. It looks like we already have a few questions, so we can go ahead and dive right in. Our first question is just about it's FLCCC and its efforts. I'm not sure if you kind of know about that, but our person shared a link here about a network of doctors that are treating long COVID. If you had anything to add on that.
Yeah, I'm not familiar with it. Certainly I'd look into it, so I can't comment about it. The next question.
Yeah, the next question is long COVID covered as a pre-existing condition under disability insurances?
Yeah, I mean, all medical conditions are covered unless specifically excluded by the terms of the insurance contract. So the question of whether long COVID is excluded, it's the same answer as any other insurance, any other medical condition. Yeah, that's a whole nother topic, but essentially most insurance policies will exclude any medical condition for which you treated in the 3 months before you became enrolled in the disability insurance policy. So if you've treated within 3 months of becoming enrolled in the insurance policy, it will be a pre-existing condition unless you wait at least 12 months before submitting your disability claim, and then it comes out of being pre-existing. But this is contract language specific.
Got it. Thank you for that clarification. The next question we have is, what specific documentation and evidence is typically required? I know you spoke on what's been really successful for you, but are there anything that's kind of baseline required to support that disability insurance claim?
That's a moving target that the insurance company is going to give you, right? They're going to tell you they want to see maybe a blood work confirming that the person was infected with COVID to begin with. That's fine, you can give it, but that's really not even high on my priority list. I think there is no specific documentation. What you want to be able to do is to present as much medical and non-medical evidence as possible. And we did go through in the presentation some of the examples of what those could be.
Got it. Thank you. Our next question is, would you be willing to share a list of doctors qualified to perform the peer reviews and IMEs, or just a way to maybe find them in your area, if that's helpful?
Yeah, absolutely. So, I mean, that's something I think you should reach out to me directly on, and I'd make introductions.
That sounds great. And then a next question we have is, in cases where disability insurance claims for long COVID are denied, what recourse options are available and how do you handle that denial from a legal standpoint?
Well, if it's denied, you have a disability insurance policy that you got from work, then it's likely governed by ERISA, and you have to go through that pre-lawsuit process where you appeal the denial to the insurance company. If the appeal is denied, then you're marching on to federal court. I would stress here that nobody should handle these on their own. You really need an attorney with expertise in ERISA to handle these types of pre-lawsuit appeals. What you do on the appeal dictates the outcome, not just of the appeal, but if you're in court, the outcome of the court case. We say internally in our firm, we win our lawsuits when we lose our appeal. With the insurance company.
Great. The next question is, how should we navigate potential challenges like variations in symptoms or a lack of that standardized diagnostic criteria when you're advocating for your client?
I think the varying symptoms is can be argued, yes, it's a challenge, but that challenge can be turned to an opportunity because the varying symptoms do kind of define the condition. And I think that's when you bring in the experts here to look at, right? You should be documenting all of your clients' symptoms, right? And if you're documenting all these symptoms, and then you have an expert, a physician, looking at all of this, they can say, yeah, this is kind of the hallmark of long COVID. And what was that second part of that question, Nina?
Yeah, the second part of the question, let me pull it back up, is how would you, for like advocating for your clients with that kind of variability in symptoms, how do you handle that and just in your advocacy?
Right. So we don't run from it. We use it. We take all of those symptoms and we point out that, again, this is a hallmark of the condition, but we validate these symptoms the best way that we can with objective testing. And there's a point where you've done so much testing, you've exhausted all the testing, you've spoken to all the right folks. There's nothing else possible that your client can do. And your client is therefore either a complete fake, and all the doctors you've consulted with have no clue what they're doing because they're supporting her, or she's actually disabled.
Yeah. And then our next question is, we have a lot of people, so in this lawyer's experience, they have a lot of people who have had the vaccine but still got COVID. He said he suspects some of them are vaccine injured, but medical providers usually shy away from that as etiology. Do you have any thoughts around that or any comments about maybe how to approach that if that's the case?
I don't know if we've handled a vaccine injury case. I've heard of it. I don't know. I'd have to think about it, and I think it depends on the specific case and the treatment the person is getting. But I also suspect that the same physicians we've spoken with and we've been relying on around the country that helps with long COVID, they're also probably expertise in the vaccine injuries or no people in that field as well. I think the idea is you have to consult with those experts and come up with a game plan to build up the evidence. Don't hyper-focus on the source of the medical condition, be it a vaccine injury or an infection with COVID-19. Instead, focus on the symptoms and building up, validating those symptoms.
That makes a lot of sense. Our next question is, do you typically caution clients about what they share on social media related to their symptoms or their claims? What's your advice there?
Yeah, great question. So when a client calls us, I think that the general rule of thumb for us is just go quiet on social media. It's never a good idea because social media portrays your best day, right? For the most part, people usually post things on social media, whether it's Instagram or Facebook. That's not really a reflection of what's going on in their day-to-day lives. It's just a snapshot in time. And so we've had some cases where clients have put stuff on social media that makes them look like they're healthier, doing well, when they're really not. We've litigated that issue in court. We've won that issue in court, but I'd rather not have that wrinkle. So just as a general rule of thumb, we suggest the client stop posting on social media.
Good advice. And then our next question is, can you elaborate on ways to establish eligibility for long COVID disability insurance claims, particularly in cases where the symptoms are maybe less visible or fluctuate?
I think that's the essence of the presentation, right? Everybody's symptoms fluctuate and are less visible. Less visible is just another way of saying inherently subjective. You can't see it. So it's all the testing that we have discussed. I think that's really the only way, medically and legally, to go about establishing disability. It is really boils down to documenting. And this is a quick answer to a question, but I wanted to mention this. I know all of this is a high cost. Putting all of this appeal together, all this evidence, it's a high cost, but it's an even higher cost not to do it. It's a high cost to the client not to get paid.
Thank you for answering that second question. This is more of a personal question, but someone just asked, how did you get into long COVID claims and kind of handling those cases?
I've specialized in disability insurance claims since I was a law clerk at the University of Miami, and that's the only area I've practiced in. So I think long COVID claims, it's just something that as a law firm that has that focus on disability insurance, we get those type of calls, and we increasingly got calls. And as we came up with our strategy for long COVID cases, I guess word started to spread amongst the community of, well, this firm is successful in handling these types of cases a specific way. And it just has that kind of domino effect of people reaching out to us. And within our already specialty of disability insurance, we've even specialized even a bit more in long COVID.
Awesome. I think that's all the questions that we have time for today. So thank you so much, Edward, for answering our questions, and thank you to you all for submitting them. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.